The following is a presentation prepared by Judge Stephen E. Brown to explain the criminal arraignment calendar in Grace Harbor County, District Court, Washington State as of 2013. The purpose is to provide case participants and others with the information needed when involved with a criminal case in Grace Harbor County. A judge may use this script or one similar at the beginning of an arraignment calendar in Grace Harbor County District Court.
I'm Judge Steve Brown. This is the arraignment calendar for misdemeanor and gross misdemeanor cases filed in Grace Harbor County District Court. This may be your first appearance in this court on a criminal charge. Before we deal with each case on the calendar today, I'm going to talk to you about our court procedures so that you have at least some idea of what to expect today and in the future. If you checked in at our court office, the court clerk provided you with our arraignment information sheet. Most of this information is also available in our Criminal and Traffic Procedures pamphlet located at the court's pamphlet rack at our customer counter and online at the Grace Harbor County website. An arraignment is generally your first appearance in court on the citation or charge where you are called upon by the judge to enter a plea. The judge or prosecuting attorney will read the citation or complaint to you to inform you of the charge. Next, it will be confirmed that you understand your constitutional rights. The judge will inform you of the maximum possible punishment and mandatory minimum punishment, if any, if you are convicted. After informing you of these matters, you will be asked by the judge if you are ready to enter your plea. You may plead not guilty or guilty. No testimony is taken or evidence presented at the arraignment. All persons accused of any crime, including traffic, fish and wildlife, parks, and natural resources offenses that might result in a jail sentence, have the following rights. You have the right to remain silent. That means that you do not have to say anything about the offense or offenses today or in the future. Anything you do say about the offense today is being recorded and can be used by the prosecution to convict you. You also have the right to be defended by a lawyer and have the lawyer present at all hearings, including this one. The lawyer can be one that you hire yourself or a public defender if you cannot afford a lawyer and qualify as indigent under the state poverty guidelines. There are forms available on the back table in the courtroom and from the court office called indigency screening forms. If you intend to ask the judge to appoint a lawyer to represent you, one of the public defenders assigned to this court, please fill out one of those forms. Having the form ready when your case is called will save you some time. The judge will review the information you provide and determine according to state published guidelines if you qualify. The clerk will then give you information containing the name, address, and phone number of your lawyer. You should read the lawyer's information sheet and contact the lawyer if you have any further questions. You also have the right to have your case decided by a jury. A jury consists of 6 people chosen from the community. A jury trial begins with you being presumed innocent, and the judge will tell the jury that they are to consider you innocent unless the prosecuting attorney can prove your guilt to them beyond a reasonable doubt. The prosecutor will try to do that by calling witnesses such as the arresting officer and any others who saw what happened, and by presenting other types of evidence such as writings, photographs, or the results of laboratory tests. You have the right to be present when this evidence is being presented to the jury so that you can see, hear, and question the witnesses called against you. This is called the right to confront and cross-examine the witnesses against you. If you have a lawyer, she or he will do that for you. You or your lawyer may also make objections to other types of evidence under the rules of evidence. Once the prosecuting attorney finishes presenting evidence, you are given the opportunity to present evidence. That means you may do so, but you are not required to do so. You may call witnesses to testify for you, and if you ask the court to do so, the court will issue orders to your witnesses directing them to come to court for you. These orders are called subpoenas and will be prepared for you at no expense to you by court staff. You may also testify at your trial if you choose, or you may remain silent at trial. If you choose to remain silent, the court will tell the jury that they cannot use your silence against you in any way. In other words, the jury cannot assume that you are guilty simply because you do not tell them what happened. You have no obligation to testify. If you do choose to testify, you will be called to the witness stand and placed under oath in the same manner as any other witness. You would be questioned by your lawyer if you have one, and cross-examined by the prosecuting attorney, and perhaps questioned by the judge or by the jury. You also have the right to a speedy trial. That means your trial must begin within 90 days of the date you enter a not guilty plea if you are released from jail pending trial, or your trial must begin within 60 days if you are held in jail awaiting trial. There is one other type of trial that you can consider, and that is a trial to the judge alone, a bench trial. You may give up your right to a jury and ask the judge to listen to the evidence and to decide whether the prosecution has proved guilt beyond a reasonable doubt. No matter which type of a trial you choose, if you are found guilty, the judge does the sentencing. If you are found guilty at trial, you may appeal the question of guilt to the next higher court. An appeal is a request for the next court to review what occurred in this court to ensure that the law was correctly applied, that your rights were properly protected, that there was a factual basis for any finding of guilty, and that any sentence imposed was lawful. If you are not a citizen of the United States of America, whether or not you have lawful immigration status, a plea or admission of guilt or a finding of guilty after a trial may result in detention, deportation, exclusion from the United States, or denial of naturalization or other immigration benefits, depending upon the specific facts and circumstances of your case. In some cases, detention and deportation will be required. You are not required to disclose your immigration or citizenship status to the court. You should tell your lawyer, because you have the right to receive advice from your lawyer about the specific impact that this case will have on your immigration status. If you decide to plead guilty, by pleading guilty you are giving up all of these rights except the right to have a lawyer assist you. You may request to have a lawyer or public defender here to help you through a guilty plea and sentencing. You will be required to read over and sign a written statement on plea of guilty, which will be submitted to the judge before the judge may accept your guilty plea. After accepting your plea of guilty, or after a jury has returned a verdict of guilty, but before announcing the sentence, the judge will ask you if you have anything to say on your behalf. The judge may review the police report and witness statements if available. The judge may take into account your criminal history, if any, where appropriate. In some cases, the judge will refer you to a probation officer for a pre-sentence investigation. In such a case, the sentencing will be continued until the probation officer's report is ready. A not guilty plea denies the charge, and none of your rights are waived unless you expressly wish to do so. The next hearing will be a pretrial conference where the prosecutor will be present. You and your lawyer, if you have one, are required to be present. At this conference, all motions are scheduled or heard, and a jury trial date is set or confirmed if already set. Information is exchanged about the evidence and witnesses in the case. Judge Copeland and I hope this presentation will assist you. If you have any questions about the information I covered or something else related to your case, please ask one of the public defenders assigned to the day's calendar. You may also ask the judge when your individual case is called on today's calendar. Thanks for your attention.